Afternoon and welcome to the fourth webinar in our series of Back to Basics for 2025. Today we are preparing and dealing with completion, and apologies, like so many completions, ours has been a little delayed starting today. Ian served a completion notice on me and is demanding interest if we don't get started soon. So we will do. How are you, Ian?
Very well, very well. I'm just worried that whenever anyone mentions interest at my webinars, I think they're attending the wrong webinar because my webinars aren't interesting.
Well, no, but you'll get you at the Law Society rate, and most people aren't that interested in what the Law Society think anyway. So, okay. So here we are at completion, fourth webinar in 4 months. I think we've actually got to completion slightly quicker than the average transaction these days, which I think is 150 2 or 3 days. So, really glad for people attending. It's been wonderful to see the numbers attending, and we are very grateful for you doing it. Hope you've found them useful. In the new year, we have one on completions, on registration, which we'll send you details on. And just so you know, next week we have a end of the year review on all of developments in property law. And again, we'll be sending you details of those after today's session. But first of all, Ian, if you could just move to the first slide.
Gladly.
So, as well as promoting events like this and supporting roadshows, which we do with Ian and other providers, we do have Stewart Solution. It's an online ordering system, and it's ideally suited for completion day nightmares because you are in total control. It's all online. You can get cover up to £20 million for the most popular policies, and there are over 150 standard transactional coverages on there. It's a simple 3-step process to get a quote, and you can get a quote and draft policy in less than 60 seconds. The great thing is you are in control then. If you need it that day, you can issue it straight away. If you're just getting a draft for approval, you can save the draft and then come back in and date it. And if you have a particularly hellish Friday for your completions, as no doubt some of you will be having towards the end of December, then most policies can be backdated up to 30 days. So if you miss it on the Friday, you can come back in on Monday and issue the policy yourself. We will then invoice you at the start of the next month. Important thing here is it's a 24-hour, 7-day-a-week system. So we know that many of you will be in the office very early on some Fridays dealing with completions. Some of you may be getting files ready the weekend before. So you can go in, order the policies and issue them if you want to. You're in total control. Where problems are more complex, you can speak to our underwriters through the online system. You can a drop-down box will appear. You can add details of documents, plans, upload those and send them through. We will get back to you. And then if we can go to the next slide. Thank you. So there are the details. If you want to look at Stewart Solution, please go to the website and sign up or get in contact with me. We'll send you some login details, and then you can go in, have a look around, order policies if you want to. If you don't order anything, that's no problem. But if you do, as I said earlier, you will be invoiced at the start of the next month. If you have any other queries about the services we offer, please contact the business development team on that email address. And as well as these sessions, as I mentioned earlier, we have the review of the year. We also have monthly forums for commercial and property lawyers. So you can join those. We can send you details. If you're interested in any of those, get in contact with me. We also do in-house training. I was doing yesterday for a law firm, talking about the regulatory requirements of title insurance, and also really how you should be reporting to your client to make sure they're fully aware of what title insurance does and, more importantly, doesn't do. So with that, Ian, I'll hand over to you to start completion.
Thank you very much. And a massive thank you to Stewart Title for sponsoring these events, and a massive thank you to you for attending them. The numbers attending always amaze me, so I really appreciate it. Just sort of flowing on from what Robert was saying there. As of next year, if you have any specific training requirements or topics that you think would be useful for webinars, if you let either myself or Robert know, we will have a chat and see if we can provide that training. And the other thing is, I can't proceed without mentioning the conferences that we've held this year up and down the countryside. Yesterday was the last one at Peterborough, sponsored by Stewart Title. The numbers were amazing. You know, everyone says you can't have a conference in December. Everyone's too busy. Everyone's lining up all their work or contemplating holidays or whatever. The numbers were absolutely astounding yesterday, as they have been throughout, to such an extent that we're organising conferences next year. Because Stewart Title sponsor those conferences along with a company called Move Reports, we're able to offer them free. And again, it's a huge thank you to Stewart Title for that, and an invitation to anyone. We're just sorting out dates and locations for next year's conferences, and if you get the opportunity, come along. They're really good. You know, ignore me, but we've got some great speakers that come along, some sponsors that come along and explain about services, etc. And the feedback that I've had today as a consequence of the conference yesterday really is heartening, on the basis that we're doing something right, and as a consequence of doing it right, we're going to do it again. So a huge thanks to Stewart Title for that. Anyway, let's talk about preparing for completion and just make sure that we are on the right track with regard to process and procedure. As I've mentioned in previous webinars, I have dissected the conveyancing process and looked at a sort of an old-fashioned transaction. We're exchanging contracts. We have now exchanged contracts. We're preparing for completion with the intention of an imaginary completion, say, for example, on Friday of this week. Important that where we are acting on behalf of a seller, that we audit our title pre-completion and satisfy ourselves that any documents that needed to be handed over on completion are available. As we're dealing with registered land in the vast majority of transactions, all we've got to worry about are any documents that are disclosed in the official copies of the register. If we have the originals of those documents, we need to make sure that they're made available to the buyer. And therefore, if we're going to be sending them to the buyer on Friday, let's audit the title today, make sure they're available, put them on file or put them somewhere electronically, perhaps within our case management system, so that they can be dispatched. The hard copy document also made available so it can be put in the post. So, as far as acting for the seller is concerned, as we're getting up towards completing, assuming we're going to complete on Friday, hopefully we have already dealt with within TA13 how we're going to be dealing with notices that are recorded on the title, and in particular we've identified notices that will require removal on Friday. And either we'll remove them, or alternatively within the form TA13 we will have given an undertaking or wording of an undertaking that we're prepared to provide for the buyer on Friday. So again, if I'm lining up this completion for Friday and there are notices on the title that require removal, it is necessary for me either to remove them using the appropriate application to the land registry, or an undertaking to remove them, in which case I need to think about my firm's policy with regard to undertakings and the practicality of the wording of the undertaking, who's going to sign it. We'll park that for the moment. As I've mentioned to you already, one of the things that is a pinch point with regard to the conveyancing process and could cause a particular headache for the buyer, that could then transmit to a headache to me, is the ability of the buyer's solicitor to comply with any restrictions on the title. So again, might be appropriate, if I've got time, to audit the registered title. Is there a restriction on the title that the buyer is going to have to comply with? Am I comfortable that the buyer can comply with it? Have I got a plan in case the buyer then comes back to me and says, I've got an issue with regard to the restriction? If the buyer can't comply with the restriction, the buyer will be unable to register themselves as proprietor and may call upon us to assist with regard to compliance with the restriction or removal of the restriction. Again, if I was of the view that there's going to be a problem on Friday with regard to the restriction, or a problem for the buyer post-completion with regard to compliance, I might be thinking about assisting the buyer in an application to disapply the restriction, or I may, if I think the position is that the restriction definitely can't be complied with, make an application to disapply today on behalf of the seller as proprietor and on behalf of the buyer as the potential proprietor after completion. With regard to unregistered land, I do need to check if there are any land charges secured against the name of the seller or previous sellers and determine whether or not it's going to be possible for me to deal with their removal before completion or the provision of an undertaking at completion. Back to undertakings in a moment or two. We've already talked about land registry notices, and again, as far as a notice is concerned from a seller's perspective, there may be notices in the charges register of a registered title that are protecting an interest in land that will remain an interest in land post-completion, the most obvious of which will be a restrictive covenant. On the other hand, if there is a notice that's going to be removed from the register, we need to make sure that we're going to be capable of removing it. Where the notice is protected by a unilateral, is protected by its unilateral status, that would be a relatively simple task. Where the notice is protected by an agreed notice, that the interest is protected by an agreed notice, that could be a difficult task. It's important that we appreciate timeframes for dealing with removal of a unilateral notice or an agreed notice. Where we don't have the consent of the owner of the interested land to which the notice relates, we could be talking about a time frame of anything between 3 months and 9 months to deal with the removal of a notice. And if that's the case, that's going to wreak havoc with undertakings that will be required to provide to the buyer at completion. So again, all I'm suggesting is that we do an audit of the title. If there are notices that are going to be removed from the title, have we dealt with them? Are we going to deal with them by way of undertaking? Are we going to be able to comply with our undertaking? At the bottom of this slide, I refer to section 77 of the Land Registration Act 2002. This is quite a useful weapon where there's a notice or restriction on a title that I know is going to be a problem for a buyer. If I can prove that the restriction or notice was lodged on the registered title and the applicant didn't have reasonable cause to lodge it, then I can invoke section 77, which enables me to recover any loss I sustain as a consequence of the notice or restriction being on the title. So if I can prove a notice or restriction shouldn't be on the title, and I can prove that I'm sustaining loss as a consequence, I can use section 77 to attempt to persuade the owner of the interest in land to remove it, or if I have to make an application to seek removal of the notice, to claim any damages or loss I sustain as a consequence of its being there. And the point I want to labour here is that loss could be contractual interest that I incur as a consequence of my inability to complete in connection with the buyer, and my loss would be the contractual interest I'm due to pay the buyer, and the claim relates to the fact there's a notice on the title that shouldn't have been there that's prevented me from being able to complete my transaction as I'm contractually obliged to do so. So we talked about agreed notices and unilateral notices. We can skip over those slides, not sort of an issue, but both agreed and unilateral notices, the applicant must have had reasonable cause to lodge them in order for the notices to remain on the title and in order to avoid a claim under section 77. Something I haven't mentioned so far, or I mentioned briefly when we talked about preparatory steps up to exchange of contracts, is something I want to deal with in a little more detail this afternoon. Whenever I encounter a residential conveyancing transaction and I'm told when I'm acting for a purchaser that there's an issue with regard to a matrimonial or partnership split or a relationship breakdown that's a precursor to the sale of the property, alarm bells ring. In an ideal world, I would like at the exchange of contracts the property to be empty, and I would like both parties to the transaction, both co-owners to the transaction, both parties to the relationship to want and to desire the sale of the property. That's my ideal. In those circumstances, assuming I'm dealing with the contracting parties, I'm comfortable that I'm going to be able to obtain vacant possession at completion. That's one end of the spectrum. At the other end of the spectrum is a situation where the two parties that own the property are at war with one another, or the property is owned by one, but another is in occupation, or there's a dispute with regard to the extent of the beneficial ownership, or there's a sort of an attritional war going on between the parties concerning maintenance, concerning children, access to children, whatever it may be. And the problem that I can tell you about, having from bitter experience encountered this in connection with transactions, is the fact that one party or the other decides to throw a spanner in the works to say, I'm not vacating at completion unless I get more maintenance, unless I get the arrangement that I require with regard to access relating to the children. I'm not doing what I'm contractually obliged to do as per the contract. I'm going to create a nuisance for myself in the hope that that nuisance encourages my former partner, my former spouse or whatever, to do what I'm wanting them to do. So, golden rule. If there's the slightest hint of a spouse being in occupation that isn't a co-owner of the property, we really want them out before exchange of contracts. If they're not out before exchange of contracts, whether they've signed the contract or not, whether they've signed confirmation that they will provide vacant possession or not, I want, or I'll tell my buyer client just to be on guard that we might have a problem or issue right up to the day of completion or even on the day of completion itself. The next point that I think is important to understand and appreciate is just because there's a homes rights notice does not make the position any better or worse. You could have a right of occupation protected by a homes rights notice, but you could have a spouse or civil partner or indeed a third party in occupation, and their actual occupation is sufficient notice to be binding on a buyer for value. So this issue about who's in occupation of the property, is there a dispute between the parties who own the property or a party in occupation of the property and the party that owns it, is an important issue to be determined, and planning is required in case worst possible scenario, far end of the spectrum issues arise. So ideally, if there is a party in occupation, they've left before exchange. If they haven't, but they've consented to provide vacant possession, and I was concerned whether that is in fact going to be the case, or my client is concerned that that is going to be the case. If today is Wednesday and I'm completing the purchase on Friday, I might ask my client to inspect the property today to see if the person that's in occupation is still in occupation, and if they are in occupation, just to take soundings as to whether or not, you know, everything appears to be fine and they're packing up or have packed up and got removals sorted, etc. I'd rather the client do that and report back to me that everything appears well, or they report back to me and say, hey, look, there appears to be a problem. There's a spat between the person in occupation and the owner of the property, or there's some bad will as between them or something of that nature, in which case I can potentially address the issue and deal with it. Sorry, I'll just jump to the slide. I'll just go back. So again, caution is required with regard to persons in occupation and the provision of vacant possession. I can turn this into a slightly different route and talk to you about a property that's sold subject to a tenancy, or the property that's currently let and the seller has advised that the tenant will vacate at completion. Again, exactly the same principles apply. A prudent move is to say to your buyer client on Wednesday, go and have a look at the property this evening, go and talk to the tenant and just make sure that all is well with regard to the tenant providing vacant possession. A good practical tip to prevent a problem arising, and what I don't want to happen is on Friday, removal van outside the property, purchase price paid over or about to be paid over, then we find out that whoever's in occupation is refusing to vacate. So the other issue with regard to land registration is the issue of restrictions. And again, throughout the transaction, right from the very start, right the way through to completion, when acting for seller or buyer, if there are restrictions on the title, are we going to be able to comply with those restrictions? One, and two, are we going to be able to comply with those restrictions within the time constraints that are generated at completion? Do watch out for Form A restrictions, which are placed on a title to indicate the existence of a tenancy in common. Just making another practical point here, where a tenant in common dies, a Form A restriction might not protect the personal representatives of the deceased, so you might see a Form N or Form Q restriction lodged in order to protect the position of the personal representatives of the deceased. Again, any indication of a change in circumstance between exchange and completion, death of a co-owner, for example, again, you need to reevaluate the situation when acting for a seller or buyer to determine whether or not you're going to be able to complete or obtain unsigned documentation to facilitate completion. Again, caution required, as I mentioned. As far as double L restrictions are concerned, we may encounter a transaction where a property is subject to a double L restriction. This is a restriction registered against the title to protect the seller, the owner of the property, the seller, in our imaginary conveyancing process. The idea behind the double L restriction is that the seller, solicitor or conveyancer is going to verify their client's identity. And this is a very useful restriction that can be a distinct disadvantage as far as, distinct advantage as far as a buyer is concerned. Because with regard to a double L restriction, the seller's solicitor is verifying that the party to the sale, the party that we've agreed to complete the transaction with, is in fact the registered proprietor of the title. It's a sort of another belt and braces scenario to prevent seller identity fraud. The reason that some solicitors or conveyancers don't like using double L restrictions is because of the imposition placed on the seller's solicitor or conveyancer during the sale, because they're being asked with regard to a double L restriction to verify their client's identity. Again, with regard to this point, what I'm really alluding to is for a buyer's solicitor and indeed a seller's solicitor to be aware of the potential for fraud, seller identity fraud. And this isn't just an issue when we're verifying identity when we're onboarding the seller client at the start of the transaction. It's something that our client and our firm needs to be aware of throughout. So if I'm acting for a seller, I've performed my client's verification, identity verification at the start of the transaction. I might have checked it again when my client sent the signed contract back to me. I might check it again when my seller client has signed the transfer in readiness for completion. And again, it's a case of constant awareness. My seller client might not be who they say they are. As far as the need to assess risk is concerned, it depends on circumstances. You know, the client you've acted for the last 20 years, who you've bought and sold 5 properties for, the risk of seller fraud or imposter fraud, minimal. The client that you've never acted for before, that you're dealing with at a distance and virtually, risk potentially high. Again, it's just something that requires awareness throughout the transaction. Even on the day of completion, I may have to assess risk with regard to seller identity fraud. That wouldn't apply in the first example I've just given you, but might apply in connection with the second. We've talked about disapplication, modification and cancellation of restrictions. We need to be aware of it and need to be aware of when it can be used, and need to appreciate that no matter what we do with regard to removal of a restriction, it's not going to be a quick fix. So this is a particular issue for a buyer, but is also an issue as far as a seller is concerned, given the fact that the seller could be left with being required to assist the buyer where there's a restriction on the title that can't be complied with. Just going to have a look in the chat. I think someone's putting something on there, so just bear with me for a second. Oh yeah, Steve just said if you have any questions or queries, please put them in the chat box. Forgive me, I thought that was a question that was being posed. Okay, disapplication is the quickest way. Well, that's wrong. The quickest way of dealing with a restriction is to get the restrictioner to either agree to its removal or to comply with whatever you're asking the restrictioner to do. But where that isn't the case, we should think about disapplication. The problem with disapplication it is a temporary removal of the restriction. It isn't permanent. But because of its temporary nature, it's an easier process to apply for during the conveyancing process. So where time is an issue and there's a restriction on the title that our buyer, as of today, announces he's not going to be able to comply with, we, either acting for the seller or the buyer's solicitor, could apply to disapply the restriction. It's unlikely that we're going to get this application before we're due to complete on Friday, but if we submitted an application today, the chances are that our application could be processed within the priority period of our land registry search, thus alleviating a problem with regard to the need to submit a new search. I mentioned Section 77 of the Land Registration Act 2002, quite an interesting emergency provision within the Act that can be used as a lever to get a non-compliant restrictioner or a non-compliant owner of an interest in land protected by notice to listen to us and to collaborate with us in connection with removal of notice or restriction depending. If we sustain loss, we can recover that loss from someone who allows a notice or restriction to sit on the title when it shouldn't be there. As far as unregistered land is concerned, again, Wednesday afternoon, we're due to complete on Friday. If there is an epitome of title or an abstract of title, we should today go through the document and check all the original documentation is in place, put it in order, in readiness to be dispatched to the buyer's solicitors on Friday afternoon. Documents that are often missed with regard to the epitome of title and also missed when we send the bundle of deeds to the buyer are land charges search against the estate owners for relevant periods. The other thing that we need to think about if we're dispatching the original title deeds to the buyer's solicitor, as required to do within our TA 13, we need to think about a doomsday scenario. What happens if the documents are lost in transit from our office to the buyer's solicitor's office? And what I would say here is if there isn't an epitome of title on file that we could certify as a true copy of the original, it may be prudent to take copies of the title deeds this afternoon and put them on the file or put them somewhere for safekeeping, so that if the documentation that is sent off to the buyer's solicitor, the original documentation is lost in transit, we've got secondary copies that we can make available to the buyer to assist in their first registration process. Again, that's something that's often overlooked and can, in a sort of nightmare scenario, create a problem. As far as that is concerned, an important point. As far as documentation is concerned, it is at the buyer's risk at completion. So in other words, if it's lost in transmission from the seller's office to the buyer's office, it's at the buyer's risk, as I say, when it leaves the seller's solicitor's offices. So the buyer's solicitors may be asking the seller's solicitors to make sure that copies are retained in case documentation is lost in transmission. Okay, right. The next thing I want to talk about are searches that a buyer ought to undertake. There are some firms, if we were completing on Friday, that would undertake a land registry search today, an OS1 search today. Why would they do that? They would do that, or they may in fact actually do the search on Friday morning, if they really want to sort of live life on the edge, as it were, because they're then going to maximize the period of priority beyond completion. As I mentioned to you, being the cautious character that I am, I would probably do an OS1 search the week before completion. Hopefully I'll get my search result back same day. I can then audit it. If there are no entries, happy days, I can mark my file or my case management system and safely proceed to complete. If there are entries, of which I'm aware of, a week before completion, that would probably give me some time to notify the seller's solicitors in the hope that whatever the adverse entry relates to could be attended to allow completion to take place. If I were to do a land registry search today and it revealed an adverse entry, a notice protecting an option agreement or a second charge or something of that nature, I'm probably going to have sufficient time to extract from the seller's solicitor an undertaking. But as we'll see when we talk about undertakings, there is a risk in accepting an undertaking from the seller's solicitor. There's a particular risk in accepting such an undertaking right at the 11th hour with regard to a transaction. You know, if the notice relates to a second charge, then I'd be asking the seller, well, when did you take out the second charge, and why didn't you disclose the fact that you'd taken out the second charge at the start of the process rather than 2 days before due to complete? We are required, if a land is unregistered, to a land charger's search against the name of the estate owner, the seller, for their period of ownership. And again, caution needs to be exercised with regard to the name of the seller, etc. And as far as land charger's search results are concerned, again, I'd want my search back to facilitate sufficient time to investigate what the land charge relates to it and to be able to remove it by way of discharge. Those are searches that are performed by the buyer's solicitors for the benefit of the buyer client. The next search on my list here is a bankruptcy search. And this is a search that's undertaken against the buyers, but is undertaken by the buyer's solicitors against the names of the buyers, and is undertaken in order to protect the position of any lender, assuming a lender is facilitating the purchase by way of mortgage advance. And the idea behind a bankruptcy search is we need to investigate on behalf of the lender our client's financial status. If our buyer client was made bankrupt and a lender was to dispatch the purchase price into our client account this afternoon, then there is a risk that the funds that have been dispatched that are now sitting in our client account to facilitate purchase are intercepted by an insolvency practitioner, in the example I've just given the trustee in bankruptcy, and then form part of the bankrupt estate, which at its heart is going to involve the use of the funds to discharge the creditors of the bankrupt buyer, and is not likely to be used to facilitate the purchase of the property, which is what it was designed to do. So you'd always do a bankruptcy search on behalf of the lender against the names of the buyers to ascertain their financial status. The next thing I mentioned on the slide is a company search. There are some practitioners that say if we're buying from a limited company and we're acting on behalf of a purchaser, a company search isn't necessary because any issues relating to title will be recorded on the title. There's two schools of thought. One is that first position is correct. The second school of thought is that a company search might reveal an issue that that wouldn't be necessarily recorded on the title. Here I'm thinking like a corporate voluntary arrangement or a peculiar feature of some form of administration that we might want to know about. So again, I would always advocate that where we're buying from a limited company, we do a company search, even though the land may well be registered. The penultimate point on the right-hand side of the slide is an interesting one. Where we get our search results back and there are adverse entries, what do? Well, the first thing, if we park bankruptcy searches to one side for a moment or two, the first thing that we do is we notify the seller solicitor of our search result. And depending on the search result, if the matter is capable of being addressed and remedied, then hopefully that addressing and remedying will take place quickly, meaning that the issue is clear or resolved by the time we're due to complete. If it isn't, but it is not a question of it being incapable of resolution, just that it's not going to be resolved in time to facilitate completion, the buyer's solicitors and seller's solicitors need to think about whether or not an undertaking could be given to the buyer from the seller that enables the transaction to still to proceed. Leave that for a moment. So we've talked about those issues so far. We haven't mentioned the Law Society's Code for Completion by Post, and now is a good time to do so. Within the TA13 form is a statement from the seller confirming their willingness or otherwise to comply with the Law Society's Code for Completion by Post. What this code does is require the seller, or the seller's solicitor or conveyancer more accurately, to act as an agent for the buyer's solicitor or conveyancer. The code sets out what that agency relationship requires. It, in essence, requires the seller's solicitor to notify the buyer's solicitor as soon as the completion monies have hit the seller's solicitor's client account. It requires the seller's solicitor to act as the buyer's solicitor's agent at completion, meaning that they must date the transfer, the date of completion, and they must send off the transfer duly executed by the buyers to the seller's solicitors for transmission to the land registry in due course. I was just speaking this morning in connection with a webinar concerning the use of electronic signatures in connection with transfers, and there was a discussion about whether a transfer, TR1, has to be signed by the seller's solicitors and the buyer's solicitors. Well, of course, it has to be executed by the sellers in order for the title to be transferred to the buyers. Does a TR1 have to be executed by the buyer? Well, the answer to that is yes, if it contains some form of indemnity covenant, or yes, if it contains any form of personal covenants that the buyer is entering into. And of course, yes, it ought to be executed by the buyers where the buyers are buying as co-owners. Because in box 10 of the transfer, as I mentioned to you on the last occasion, it will specify how the beneficial interest is to be held. The buyers executing the transfer is in essence confirmation of their consent or their acceptance of that status. The transfer has to be dated the day of completion, can't be backdated or anything else. And there is an implied undertaking in the Law Society's Code for Completion by Post. The seller's solicitor will dispatch their client's part contract to the buyer if it hasn't already been sent. That the seller's solicitor will send the executed and dated transfer to the buyer's solicitor on the day of completion, and the seller's solicitor will provide any appropriate undertakings that were to be provided courtesy of statements within Form TA13. I mentioned at the bottom of the slide here this point about undertakings, and the important point here relating to undertakings is this. We all are aware that an undertaking is a professional promise made during the conveyancing process that is or must be complied with or adhered to. An undertaking can be oral or in writing. An undertaking can state on its face that it's an undertaking or may not state on its face that it's an undertaking, but by the very nature of the act or acts required within the conveyancing process, it is deemed to be an undertaking. Your firm should have an undertakings policy. You should be aware of your role as a fee earner, solicitor, conveyancer, or paralegal, the authority that you've got to give undertakings on behalf of your firm. I'd always say I'd want any authority with regard to the giving of an undertaking to be an express authority. In other words, your boss, your line manager, your head of department has confirmed to you in writing that you have authority on behalf of the firm to bind the firm to give undertakings in the following circumstances. The most common sort of undertaking that is highly unlikely to generate any professional problem, but is nonetheless an undertaking, is the implied undertaking on exchange of contract to remit the signed contract on your client's part to the other side as part of the exchange process. That is an undertaking. A failure by you to submit the contract or the transfer to the other side in the time frame required would be a breach of undertaking that potentially could lead to contractual liability on the part of your client and professional misconduct risks with regard to your firm. I mentioned on slides here something called an early completion procedure. I just want you to draw it to your attention. Highly unlikely to encounter it, Certainly you wouldn't encounter it where property being sold is subject to an institution's mortgage, but in limited circumstances where the early completion procedure applies, what happens is the buyer is registered as proprietor on the day of completion. The buyer's charge is registered as a first charge on the day of completion or as soon as possible thereafter, but the seller's charge remains on the title until the charge is redeemed. You might not see the early completion procedure, but be aware of its existence, and where it does exist and where it does apply, there is a risk that the status quo with regard to the title, as I show you on the slide, remains, and everyone forgets to discharge the seller's charge, so it sits on the title and potentially would be binding on the buyer if circumstances where the seller were to default. I've never actually seen this happen, but I do know when the early completion procedure was launched by the Land Registry, professional indemnity insurers were concerned that the process would take place, the buyer would become registered proprietor, the proprietor's charge, the buyer's charge would be a proprietor's charge in the charges register, the seller's charge would remain in the charges register, everyone's forgotten about it, the lender wakes up and says, I have a charge on this title, it hasn't been discharged. The lender theoretically would be entitled to bring a claim against the buyer, who would be the registered proprietor, for their repayment of the charge, and it would be for the buyer to seek recompense or an indemnity from the seller whose liability the charge relates to. Okay, the next thing I want to talk about is delayed completion. And I smiled when Robert talked about the delay today and the need to serve a notice to complete, etc. If you're ever in a situation where a residential conveyancing transaction has gone wrong, there are a few important things to be aware of. The first is, as my old father used to say to me, in circumstances where you're under stress or under pressure, don't lose your head. Okay, take a step back, have a think about it, think about what's gone wrong. Don't sort of mull over the disaster, but ask yourself, what can I do to address what's happened? So the first thing I think you do is advise the client and then explain to the client their rights and obligations. So let's look at a situation and then let's look at either party's position or stance with regard to that situation. We're acting in connection with a transaction that was due to complete today. We are acting for the seller. The buyer's solicitor told us this morning by way of email that everything was set to proceed and that wouldn't be a problem and the monies would be put in our client account shortly. We then receive an email to say there's been a problem with regard to funds, and the buyer's saying we don't know whether we're going to be able to complete today or not. And then radio silence, nothing more. Okay? So we were due to complete at 2 o'clock, it's now 2:45. We advise our client that the buyer was due to complete at 2 o'clock today at the latest. They are now in breach of contract. I'd explained to the client there are a number of steps we could take. We could sit back and do nothing in the hope that radio contact is resumed later today or in the morning and the transaction proceeds to complete. We could immediately, given that 2 o'clock has been and gone, serve a notice to complete on the buyer's solicitor, giving them 10 working days to effect completion or losing their deposit in default. We could theoretically immediately bring proceedings for specific performance in the county court, seeking an order of the court to compel the buyer to complete. The problem with the specific performance application is that it is an application relying on equity. It is an application, therefore, that is only available at the discretion of the court and that we're not guaranteed to get it and might instead be awarded damages. It's all well and good as a transactional property lawyer saying we can sue the seller or sue the buyer for default. Words are cheap, the cost of litigation significantly greater, and therefore client would need to be warned about the cost of bringing proceedings and the risk that the proceedings can be successfully defended. So we identify clients' rights and obligations. The standard conditions of sale do allow us to either claim contractual interest and or serve a notice to complete, and common law would entitle us to recover any loss that we sustain rather than recovering contractual interest. from a practical perspective, will recover practical interest, practical perspective, will recover contractual interest or the actual loss that we sustain, whichever is the greater. The problem with a notice to complete is that, one, we may be incurring costs in drafting and serving the notice the client needs to be aware of. And if we're going down the route of potential litigation, we would need a new retainer, and the client would need to understand their potential vulnerabilities to costs and what it's likely to cost them in connection with the proposed action. Secondly, we've got to be in a position that we are ourselves in a position to complete the transaction. A notice to complete is invalid, excuse me, and void if at the time we serve the notice we're not in a position to complete ourselves. And if we do serve a notice to complete, it takes effect on the next working day after service and gives the other side 10 working days to complete. The whole idea behind a notice to complete is it makes time of the essence, meaning that at the end of the 10th day, if the buyer has been unable or is unwilling to complete, we can theoretically forfeit the deposit. The problem with the theory of forfeiting the deposit is it's subject to section 49 of the Law Property Act 1925 that says a court has a discretion as to what is to happen to a deposit in the event of buyer or seller default. So there's no guarantee that a court is going to order that the seller is entitled to retain the deposit, notwithstanding buyer default, and vice versa. It all depends on the circumstances as to why the buyer has been unwilling or unable to complete. For example, sometimes serving a notice to complete just gives the other side more time to get their act together. Sometimes it acts as a great sort of incentive on the other side to remedy the default and to honour their contractual obligations, which would involve, in circumstances I've just mentioned, paying contractual interest for the unpaid purchase price between the time that completion was contractually obliged to take place and the date that it actually took place. We may also be liable to the seller's solicitors or conveyancers' legal costs with regard to the serving of notice to complete and ancillary legal work alongside it. The notice to complete, as I mentioned, makes time of the essence. It should be served on the other side's solicitors, and it should make time of the essence. In other words, giving the other side 10 working days to be able to complete the transaction, the purchase, as I mentioned. As far as service is concerned, the service on the solicitors for the buyer should be the address shown in the contract. And as far as the notice is concerned, some important points. It can't be unilaterally withdrawn, nor can it be extended. So if the other side, the buyer's solicitors in our scenario, were to email us and say, we're not going to be able to complete within 10 days, but we are going to be able to complete within 14 days, will you please extend the time to facilitate us to complete or withdraw the notice to complete? What I would do in that situation is say, well, I'm not going to withdraw it. What I am prepared to do is to confirm to you I won't enforce it, having taken my client's instructions, but I'm going to serve another notice to complete on you today, which gives you 10 days from today to effect completion. As I say, if I've served a notice to complete on Friday last week, because you failed to complete on Friday last week, I can't extend the 10-day period to run beyond, what was it, a week next Wednesday, or whatever it may be. Okay, what happens to the deposit in the event of default or in the event of breach of contract? Well, the general position is that the deposit is retained by the innocent seller or is returned to the innocent buyer, depending on who's in default. But that's not set in stone, courtesy of section 49 of the Law Property Act 1925. On the expiry of a notice to complete, where the buyer's solicitor or conveyancer, or indeed the buyer directly advises that completion won't be possible, theoretically the buyer can then lose the deposit, or the seller can retain the deposit. If the deposit was a reduced deposit, then the balance of the deposit theoretically falls due and fell due at completion. So again, it's important to be aware that we might be claiming more than the actual deposit that we've actually received. Where the buyer has paid a reduced deposit and the buyer is unable to complete on the agreed completion date, and the position is that the buyer is obliged to make up the balance and to pay that to the seller, notwithstanding the fact that the buyer will still be unable to complete the purchase. Always seems to me a bizarre scenario. I can't complete my transaction. I'm going to lose the 5% deposit that I've paid you, but I'm now going to willingly hand over to you the balance of the 5% deposit in the full knowledge that I'll never see the money again. My view is that what a buyer in that situation is likely to do is to say, well, get lost, you can't have the balance of the deposit, and wait to be sued. That's generally speaking, I think, the most common sense conclusion of a situation where a reduced deposit's been paid, buyer defaults, and seller says, I want the balance of my money. If the seller defaults, then the buyer is entitled to ask for their deposit back. Again, a buyer would be entitled to sue the seller for specific performance to compel the seller to provide vacant possession. But if that would render the seller homeless, a court would be highly unlikely to award an equitable remedy such as specific performance to the buyer. Going on, if I can, code for completion by post, we've spoken about. Deposits we've discussed, but we haven't mentioned in detail section 49.2 of the Law Property Act 1925, which is the position that gives a court a discretion as to what's to happen to a deposit. So it's not automatically retained by the innocent party. It may be returned depending on what's fair and equitable. The other point about section 49 of the Law Property Act 1925 is it gives the court a discretion in connection with an application called a vendor or purchaser summons. The Law Property Act 1925 creates a vehicle that enables county court action to be taken with regard to disputes concerning a notice to complete, disputes with regard to breach of contract arising from an inability or an unwillingness to complete, and other sort of land law property conveyancing related disputes. So section 49 gives the court a wide-ranging discretion to hear hearings concerning such disputes and creates a vehicle for those disputes to be resolved relatively swiftly. So what I want to do now is just sort of reiterate some of the points that I've made today. Number one, be aware of the code for completion by post. Familiarize yourself with it. Understand the duties and obligations that are imposed on both seller and buyer. Always check to make sure in the TA13 form that the seller is willing to abide by the code for completion by post, and if not, ensure appropriate arrangements are put in place so that your client buyer is not disaffected by the fact that the code for completion by post is not to be complied with. In order to prepare for completion, give yourself time. I don't want you to be doing the audits and checks that I've mentioned this afternoon on Friday morning just before you're due to complete, or late Thursday afternoon. You need time to be able to do your audits, to do your final reviews, etc., before you complete. And if need be, it might be that the file is checked over by a colleague or superior. Well, again, I have no objection to that. Often the most eyes you can get on a file or on a transaction or case management system, the better. Make sure that when there is a problem, if there is a problem, your client is, well, two things. One, you communicate with the other side to see what the problem is. And again, I would view, or I would maintain, subject to getting client's instructions, that a candid explanation of the system would always be the preferential route to take. I think the other thing that we need to be alive to and be concerned about is being realistic with the client. It's all well and good saying sue for misrepresentation or sue for specific performance, etc. If our client's going to be incurring £20,000, £30,000 worth of legal fees in undertaking such an exercise, they may not quite have the appetite to proceed. If we're going to serve a notice to complete, don't serve it just out of spite. Ask yourself, what am I trying to achieve by this notice to complete? Am I protecting my client's position? Is there going to be a distinct advantage in serving it? or is there perhaps an argument to say hold off and see what's happening? One of the things I see on a regular basis is where the other side go to periscope depth and just stop responding to communications, etc. That can be very frustrating. That can lead to sort of an aggressive next step, which might be the service of a notice to complete. You're probably better attempting to create some line of communication with the other side to find out what's gone on. And often the estate agent involved in the transaction can be an appropriate conduit. Be aware of what remedies could be available in the event of breach of contract, where there's an issue with regard to completion. The thing I haven't mentioned so far, if you're acting for the party that's in default, don't just sort of put your head in your hands and say, oh, crikey, we've now got a problem on our hands. Be proactive. If the other side is going to issue proceedings against us, is there something that we can do that could potentially generate a defence to those proceedings? That might be something that we'd want to consider or be able to deal with. Just clicking on a little further before we finish today, talked about that, talked about those issues. Does anyone have any questions? I'm just going to open up the chat facility and see if there are any questions other than Mr. Steve Smith with his original question. If you have any questions, put them in the chat box. I don't see anything sitting there. Anyone got any questions, any burning issues? The key with conveyancing is to do the simple things well. Effective communication, important. Reviewing your file, thinking about what happens next. Talking to the client, talking to a litigation expert where you're contemplating proceedings. Communicating with the other side and just saying, hey, look, let's be frank, what's the problem here? Is the problem an administrative problem that's going to be capable of resolution? Or do we have a fatality due to some fundamental flaw with regard to our position or a position in the chain, for example? So it's that sort of thing that can be really useful. All that's left for me to do is to thank you all very much today for attending. A massive thank you to my dear friend, Mr. Robert Kelly and his colleagues at Stewart Title for manning the IT and the technical side of things today. And a massive thank you to you for coming along. Finally, this webinar has been sponsored by Stewart Title. It has been recorded. The notes and slides will be made available to you. Stewart Title will be in contact with you. If you are an existing client of Stewart Title, many thanks for your willingness to be associated with Stewart Title. If you're not a client of Stewart Title, talk to Robert and his colleague. You may have an existing title insurer that you utilize, but there may be circumstances where Stewart Title have a bespoke policy that fits your client's circumstances. They may be more competitive with regard to premium. It may be that you feel it's appropriate to get a second choice of policy for your client, in which case I'm fairly confident that Robert and his colleagues won't mind sitting alongside an existing insurer or an existing contact that you may have. But I'm not, ladies and gentlemen, there is, as Robert mentioned, a review of the EARN next week, and we have a series of forums on a monthly basis, and we have a series of conferences that have been really successful this year and that will be repeated in one way, shape or another during next year. Thanks very much, everyone. If you're not joining us for the forum next week, or I don't have the opportunity to speak to you, either virtually or face-to-face, it is, I think, appropriate for me to say that I hope you have a lovely holiday period and season's greetings to you if you are of a particular faith. And thank you very much for your support during 2025. I look forward to working with you and enjoying your company in 2026. Thank you very much, Mr. Kelly. As ever, thank you for your assistance. One last look at the chat and the questions. I don't think there is anything there.
Someone has asked if they'll be getting the slides in. Yes, we will be sending the slides and a link to recording out to everyone. So you will get those. And obviously, if you have missed any of the earlier sessions, then please get in touch and we can send you a similar bundle for those. And please feel free to use them for training with your teams, possibly for onboarding of new support staff. We're very happy to use it like that. and there should be, as you exit, a short questionnaire. Just ask you some questions, because it's very important for us to understand the issues you're facing. So anything you can do there to answer those would help us greatly.
Yeah, I think the other thing, Robert, you know, at the conference yesterday and at the other conferences, we've had sort of slips for people to fill in to sign up to your sort of solutions online thing. As far as people attending today, is there a sort of an online version of that so they can sign up to use
The online version would be to go to the stewartsolution.com website, where there is a page to register there. So you can do it there online, or much easier, just send me your details, robert.kelly@stewart.com, and we can get you signed up and send through login details to you.
Brilliant. Thanks, Robert. Thanks, everyone. Stay safe and speak soon. Bye-bye.
See you, bye.